This program is brought to you by Emory University.
I want to get started on our second panel and introduce our moderator, Ed Philpot. Ed is a third-year law student at Emory and is executive managing editor of the Journal. As a second-year law student, he led the team that authored the Supreme Court cert petition in the case of Bullock v. Bank Champaign, which is scheduled for oral arguments next month. A native of Chapel Hill, North Carolina, Ed earned his undergraduate degrees in math and econ and a master's degree in econ from Duke University. Thank you, Ed.
Thank you, Ivana. Thank you all for coming today. I'm Ed Philpot, as she said. Before we get started, I'd like to take this opportunity to introduce our panelists. Our first panelist is Judge Paul W. Bonapfel. Judge Bonapfel has served as a bankruptcy judge at the U.S. Bankruptcy Court for the Northern District of Georgia since his appointment in 2002. Prior to his appointment, Judge Bonapfel represented both debtors and creditors in business and consumer bankruptcy cases. He's a fellow of the American College of Bankruptcy and has served as the president of the Southeastern Bankruptcy Law Institute and is chairman of the bankruptcy sections of the State Bar of Georgia and the Atlanta Bar Association. Finally, Judge Bonapfel is the co-author of the treatise Chapter 13, Practice and Procedure. I hope you brought your copies with you because I know Judge Bonapfel would be happy to autograph them after the panel.
Yes, I will. My wife will be happy if you buy some.
Our second panelist is Mr. John A. Thomson. Mr. Thomson is partner at Womble, Carlyle, Sandridge, and Rice. He's the president-elect of the Atlanta Bar Association Bankruptcy Section, secretary of the Southeastern Bankruptcy Law Institute, and he has served as a member of several American Bankruptcy Institute committees, including finance and banking, real estate, and asset sales. Last, but certainly not least, is Mr. Richard Thomson. He's a fellow of the American College of Bankruptcy. He is, a partner at Clark & Washington, before we forget that he's employed. A fellow of the American College of Bankruptcy, and he has served as the director of the Southeastern Bankruptcy Law Institute and is a board member of the Atlanta Bar Association Bankruptcy Section. Please welcome our panelists. This is a very exciting year for Emory Law School, in particular 4 of us who had the opportunity to write a petition for a writ of certiorari to the United States Supreme Court with the Emory Law School Supreme Court Advocacy Project. I believe the team is here with us today. They're Scott Forbes and Rachel Erdman, both of whom are with the Journal, and Michael Wiseman, who's over there, and me. Mr. Tom Byrne of Sutherland, Asbill, and Brennan, the Council of Records, supervised our work all along the way. Our research and drafting efforts helped to produce the first successful LSCAP cert petition to put a consumer bankruptcy question before the Supreme Court. The argument is 2 weeks from now, and we're very excited to attend, and of course, we're wishing Mr. Byrne a lot of luck. Emory law students, through LSCAP, are working to provide greater access to the Supreme Court for cases of all kinds, and we're working hard to establish LSCAP as the premier Supreme Court advocacy clinic in the 11th Circuit. At the same time, this project gives students like Scott, Rachel, Michael, and me the opportunity to participate in appellate advocacy and experience wins, like with our cert petition, and losses before the nation's highest court, but we're keeping our fingers crossed. The subject of today's panel will be the area of law that we helped to bring before the Supreme Court, specifically fiduciary exceptions to discharge with a focus on defalcation. By way of introduction, here's a brief rundown of the facts of the case, the holdings, and the existing law on the issue. The case revolves around our client, a debtor, Randy Bullock, whose father made him the trustee and beneficiary of a trust without his knowledge. The sole asset of the trust was the father's life insurance policy. The debtor learned that he was the trustee of the trust when his father, the settlor, approached him and asked him to take a loan against the life insurance policy. This is the first of 3 loans over a period of 9 years from 1981 to 1990. The first loan was to the debtor's mother, at his father's request, so that she could pay off a loan to the family business. The second and third loans were jointly to the debtor and his mother, and they were used to purchase investment interests, real estate, and later a garage fabrication mill, again for the family business. At all times, the loans, totaling about $265,000, were secured by a first mortgage on property that appraised for about $447,000. The debtor and his mother made payments on these loans for about 15 years. Notably, the trust document did not clearly prohibit these kinds of transactions. In 1998, some of the beneficiaries requested that the debtor resign as trustee, and he did. The debtor and his mother paid off all of the loans within months of his resignation. These payments, with interest, totaled about $455,000. The trust was completely whole. After the debtor resigned, Bank Champaign was appointed as successor trustee. In 1999, 2 of the 5 beneficiaries, the debtor's brother, filed a lawsuit in Illinois State Court for breach of fiduciary duty and sought to have any profits earned from the loan proceeds turned over to the trust. In 2002, the Illinois court ruled in favor of the brothers, though it made no findings of intent other than stating that the debtor did not, quote, appear to have had a malicious motive in borrowing funds from the trust. The court held the loans were self-dealing transactions and therefore breaches of fiduciary duty under Illinois law. The court awarded $250,000 in damages and an additional amount for attorney's fees and costs, and granted Bank Champaign a constructive trust over the debtor's assets, including those purchased with the loan money. The damages were an estimate of the profits earned with the loan amounts, but the court acknowledged that it would be difficult to know for certain what any actual monetary benefit was. Despite the debtor's demands, Bank Champaign has steadfastly refused to liquidate the assets in the constructive trust to satisfy the judgment. In 2009, the debtor filed Chapter 7 bankruptcy. Bank Champaign initiated an adversary proceeding to have the Illinois court damages accepted from discharge under 523A4, that is, for fiduciary fraud and defalcation. The bankruptcy court applied collateral estoppel. Here, the court held the Illinois court judgment established fraud and defalcation in a fiduciary capacity as a matter of law. The entire judgment debt was accepted from discharge. The district court affirmed, though it noted that Bank Champaign was abusing its position of trust by failing to liquidate the assets. Our client appealed to the 11th Circuit. The court took a definition of defalcation that required a failure to produce funds and which required a known breach or objective recklessness. In this case, our client was charged with objective recklessness because, in the court's opinion, he should have known that his loans were self-dealing and therefore a breach of fiduciary duty. The debtor, however, had no legal training. The court did not express an opinion on fiduciary fraud, as the defalcation by itself established non-dischargeability under 523A4. The court affirmed. Defalcation is a creature of federal common law. Courts' treatment of defalcation in a fiduciary capacity appears to require, at a very general level, 3 elements: a pre-existing fiduciary duty, a breach of that fiduciary duty through, third, some manner of default. We'll come back to the default later. Underlying these 3 main elements is an intent standard. Note that defalcation shares the company with the likes of, embezzlement, larceny, and fraud. There are 2 main ways to interpret this. The defalcation should have an intent standard similar to embezzlement, larceny, and fraud, which would be nascitur associis, forgive my Latin, or that defalcation should be distinct from these other acts and should therefore not have a similar standard, an application of the canon against superfluous language. These factors have split the circuit courts. With regard to the intent standard, the circuit courts can be grouped into 3 camps: innocent mistake, willful neglect or objective recklessness, conscious misbehavior, or extreme recklessness. Under the innocent mistake standard, no intent to defraud is required to prove a defalcation, only some failure to account. Willful neglect or objective recklessness. In these circuits, defalcation requires more than mere negligence, but less than fraud. The objective recklessness standard draws on what a reasonable person in the debtor's shoes would have known. For instance, in Bullock, our client was charged with knowledge of the law for a trustee of a trust, though he had no legal training. Conscious misbehavior or extreme recklessness. These circuits have adopted what is essentially scienter from securities law as their intent standard. In these circuits, defalcation requires that the debtor either embrace an intent to deceive, manipulate, or defraud, or depart from the standard of ordinary care. Quickly going back to the nature of the default. Courts are not clear on whether the default giving rise to defalcation requires that the beneficiary demonstrate that the trustee caused a loss of the trust property, or even that the default was monetary. This point is made especially elusive because, well, there are not many cases that arise in the circumstance when there's no loss of trust property. And there are some, but not a lot, when there is a non-pecuniary default, probably because they have some remedy elsewhere. This raises more unanswered questions, obviously. Legislative commissions and courts, going back to Judge Learned Hand, agree that defalcation is tough to define. Let's see what our panel has to say. I think the general role of acceptance to discharge are in bankruptcy.
Let me start, as I always do, by dodging the question, and we'll incorporate the well-written disclaimer from the first panel, which is we're here and whatever we say may or may not be our own opinion and certainly doesn't bind clients or me. And in the words of Judge Barbara Hauser, who is a bankruptcy judge in Texas, do not cite me to me. Some people think that means you can't cite any opinion I've written. You can actually cite an opinion I've written, although my colleague Judge Deal, who is here, will tell you don't cite me to her, even if it is a written opinion. So the question is, what is this exceptions to discharge and what role do they play? And in an overall view of the bankruptcy code, it has, I suppose, two primary objectives. One is to provide a fresh start for the honest but unfortunate debtor, and the other is to provide for an equitable distribution of the assets of the estate among the creditors in accordance with the congressionally established priority. The second objective we're not here about today. We're here about the first, which is the fresh start policy. And the fresh start policy has two conditions to it. One is you have to get a discharge, and of course 727 specifies a variety of circumstances that if a debtor commits certain types of generally dishonest, fraudulent types of acts, you don't get a discharge. We're not here about that either. This debtor, and we're assuming our debtor gets a discharge, so gets over that hurdle of some general level of misconduct towards creditors generally that says you can't get a discharge. So the exceptions to discharge exists because there are some types of debts that Congress has said simply a debtor should not be able to avoid. And so the exceptions to discharge in 523 are a set of types of debts that for one public policy reason or another, Congress has said you can't avoid those. You can't get rid of those types of debts. That's the overall scheme of the discharge ability section. And there are how many, John? 19? 19. We're going to use first names because we have two Mr. Thompsons, and they're going to call me by my first name, which I think is Hun.
Now, the code sets out 19 separate enumerated exceptions to discharge. Some of them are duplicative a little bit, but if you start reading many of them, they make sense. You can get your arms around it. It's fairness. If you're trying to get a loan and you tell a lie about the collateral or some circumstance surrounding what's going to secure the loan, that's an obsession. That's just not fair. If you submit a financial statement that is clearly wrong, it has incorrect data that would lead somebody to make a loan, that's not fair. But then what you start to see is you see Congress, no doubt due to a lot of lobbying by special interest groups that have special concerns in the financial area, that are getting further down in the weeds. They're trying to regulate certain specific kinds of conduct. Domestic support obligations, non-dischargeable. Willful injury to property, and that is, we're going to be dealing with A4, which is fraud or defalcation of fiduciary capacity. It's unbelievable how broad that can be. When you start looking at what is willful injury to property, that's another very broad characteristic or very broad category. But then you start getting down into, for instance, student loans or funds that are due back under a federal grant program that must be repaid. Those are non-dischargeable. Who would have thought probably at the inception of the act or the code that those were going to be specific areas, but some group of lenders, the student loan lenders, focused Congress's attention on that. On the one hand, in this country, we're encouraging people to become better educated. We're encouraging people to go out in many respects and get technical degrees and borrow money to get there. But if it doesn't work out, if they can't secure employment, those debts are non-dischargeable. You start going down, there's some very specific exceptions for FDIC-related penalties and a failure to maintain capital of a bank. We're going to talk further about that. That's one area that I do a lot of work in, and that's I believe, an oncoming wave of litigation and claims, and we're going to see that further develop. Homeowners association fees are very specific, but only post-petition. So you can go through the 19 areas, and you can see some very broad general characteristics where Congress is trying to make sure that things are, for lack of a better term, fair. But then you really see special interests, special exceptions starting to get down in the weeds in terms of what can be accepted.
Rich Thomson, what would you say is the impact on the debtor of accepting a debt like that from discharge?
Well, like anything, when you're talking to a client, you have to look at their circumstances, what their goals are, what's driving them having to file. They may have some very large dischargeable debts and a couple of small non-dischargeable debts. So getting them through and getting rid of the dischargeable debts puts them in a position to deal with those non-dischargeable debts, whether it's a workout with the creditor or whether it's filing a Chapter 13 and paying for them in the subsequent case. If a client comes to me and that the major thing that's driving him wanting to file is a large non-dischargeable debt or potentially non-dischargeable debt, then you really have to sit down and do a lot more homework and get with the client and explain the ins and outs and let them know and let them understand that the relief they may get may be very limited.
Is, in today's time in America, probably the closest thing, unfortunately or fortunately, depending on what side of the rope you're on, closest thing we have to involuntary servitude. It is a debt that is out there, and it does not go away. Having done this now for a while, I've been through several cycles, and I've got context greater than when I was a young lawyer starting out. Bankers used to tend to say, well, he doesn't have anything, he's bankrupt, we're not going to pursue this, I'm not going to spend legal fees, I'm not going to spend money to obtain this judgment of non-dischargeability. But what they're now seeing as we go through these cycles are entrepreneurs, developers, however, they're down, they've done something wrong, but they will come back. They will get back into the game. It's in their DNA. And this judgment will hang out there. And eventually, at least from the creditor side, which is the side that I'm on more often than not, if properly renewed, at some point that judgment, if you're diligent, has the opportunity to catch up to this debtor and the creditor feel like he's gotten some recompense for what happened.
And the flip side of that, from a policy standpoint, is if you get that huge judgment, that guy's not going to bounce back. Or if he does, he's going to bounce back in Florida, where they don't have wage garnishment.
Well, Judge Bonapfel, what do you see as the role of the fiduciary exception to discharge to replenish trust property? What do you see as its role within the general scheme?
Well, I'm not sure what I see it as, but that's what this case is about. The Bullock case is to some extent defining how expansive that fiduciary exception is going to be by looking at what is defalcation. And the basic question that we get to in this discussion is what is the level of intent that's required, if any, in connection with a defalcation by a trustee. And the potential impact of this is that is going to be how broadly is this exception going to apply when you are talking about the defalcation aspect of it. Fraud, embezzlement, larceny, or other issues that have their own intent, wrongful state of mind requirements But the concept of defalcation could imply an innocent or at least an unknowing violation, as the facts of this case, of the Bullock case, illustrate. So the question is, how broadly is that going to go, and does it expand, does this idea of defalcation expand into other areas of fiduciary relationships that are not the type of trust that was involved in this case? And two that readily come to mind are attorney-client relationship, which we generally consider to be a fiduciary relationship, and the fiduciary relationship of a corporate officer or director to either, depending on where you are in the corporation's life, the shareholders or the creditors of the corporation. So this exception to discharge A4 could take on either more or less significance depending on how the Supreme Court case rules in this matter.
Just a quick question for Rich Thomson, actually, just following up on this. We have the facts of one case before us, but what kinds of contexts do you see this in consumer practice?
In the consumer practice, the fiduciary relationship comes up in probably 4 different types of areas. You have federal and state statutes that create fiduciary relationships. Generally, for that fiduciary relationship to be non-dischargeable or create a non-dischargeable debt, the statute has to create a trust at the outset of the relationship, and typically the statute must require a segregation of accounts. Generally, you'll see these statutory type of fiduciary relationships when you're dealing with contractors. Different states have different laws, some making it a felony for a contractor to take a down payment for supplies or services on a particular project and then use them on a different project. Insurance agencies, some insurance agents, some states have laws that create a fiduciary obligation regarding premiums paid to the agent, and they must be segregated, and if they don't segregate them, then they have violated that fiduciary relationship. Landlords, a lot of my clients will have a house that they're renting out, and they don't handle their security deposits correctly. Many state and federal statutes, especially for government-subsidized rent programs, will require that those deposits be placed in a segregated account. And also you'll see a lot lottery ticket sales. Georgia OCGA 50-7-21 statutorily creates a trust requiring that the proceeds of lottery ticket sales be set aside in a separate account, and the failure to account for those sales receipts violates the fiduciary relationship. So you have various statutory fiduciary relationships. Then you have court-created fiduciary relationships. As Judge Bonapfel mentioned, the attorney-client relationships, especially with the attorney escrow accounts. That's a court-created because the rules of professional conduct are promulgated by the Supreme Court of Georgia. You'll also see often in divorce decrees requirements of trusts or money being set aside in segregated accounts for the children, for the benefit of the ex-spouse, whatever. And again, that's a court-created fiduciary relationship for the spouse that's responsible for creating that account and for maintaining it. You also have express contractual fiduciary relationships. That's where you have the family trust, where you have floor plans with automobile dealerships, where you have American Express money orders. In order to sell American Express money orders, you have to agree to an express trust agreement with American Express, and you have to set up a segregated account. Gasoline sales agreements, the same thing. You have to segregate the sales proceeds in a separate account. And those are done by contract. Then finally, the fourth area is under federal common law. The federal common law defines what a fiduciary relationship is and then looks to the state law requirements to see if that's met. Federal common law is usually invoked in talking about corporate directors, duty to creditors, and that fiduciary relationship. They will also sometimes use it to expand purely agency relationships, let's say where a son has his elderly mother's power of attorney, and they may expand an agency relationship to elevate it into a fiduciary relationship where the one party is really incapable of monitoring the other party's behavior. Again, whether or not those type of trust and fiduciary relationships, a defalcation in those relationships results in a 523A4 non-dischargeable debt is a matter of question. Typically, these 523A4 trust relationships, you have to have an existing trust res, and you have to have specific fiduciary responsibilities established at the time that the relationship is created. So when you're talking and dealing with a lot of consumer debts, and you said, well, Rich, most of that stuff you're talking about are people that are engaged in business. But a consumer case, typically, the majority of their debt is consumer debt versus business debt. And many of our cases, people that are self-employed or have these little convenience stores or whatever, the majority of their debt is consumer debt because their home residential mortgage is much higher than their accumulated commercial or business debts.
Well, can you expand a little bit on sort of the sophistication of these individuals? Do they appreciate the fiduciary capacity that they're in, or the relationship they have with the trust?
Many times they don't. Many times they're not aware that especially with the statutory fiduciary relationships, they are not aware that they're a fiduciary, and in fact, the statutes don't require an intention on the fiduciary to enter into a fiduciary relationship. Simply, if you are conducting this type of business or you're doing this type of activity, then automatically under the state law or the federal law, you are a trustee and the fiduciary relationship is established.
And this case illustrates, the Bullock case is an example possibly of an apparent lack of sophistication of the debtor, because it's a family situation. The son doesn't even know he's a trustee until his father comes and says, son, you're the trustee and you need to take out a loan from this trust I set up for you and your mother. And that's how this starts. So you can see how this developed in the sense of being an innocent undertaking by this son who's asked to do something for his father and arguably is just doing some things that the father wants to do. We don't know from the facts what happened to the father. It never says he died. So, but this case, the Bullock case, does establish a primary example, I think, of someone who is innocent in the sense of not having any idea that what he is getting involved in is going to subject him to some kind of liability.
John, can you kind of expand on the corporate context of fiduciary exceptions to discharge?
Yeah, it's, I think, split as you look at the character of the corporation that you're talking about. Certainly the directors that sit on the boards of Home Depot, of Delta, of SunTrust banks, local publicly held corporations, they're sophisticated businessmen by and large. They understand the fiduciary relationship. I will tell you, particularly back when the economy was heated, 2004, 5, 6, there were people that were being appointed to boards of corporation, to boards of financial institutions that viewed it as an honor, but perhaps didn't have the corporate sophistication. A brief story, I was in a Publix near my house and I saw my old football coach from high school. And we talked, how you doing? He said, listen, I got to run. I'm on the loan committee of a new de novo bank. That was the first time it hit me that our economy was sorely overheated. And it is that type of thing. We are now seeing those officers and directors, particularly in the FDIC financial institution context, coming in with summons in their hand. They've been served with lawsuits, and it is alleging a breach of their fiduciary duty to The American taxpayer is essentially represented by the FDIC as conservator for the bank. There are other suits that are being brought, for instance, by creditors' committees that are appointed to oversee the liquidation of former public companies, where they are essentially creditor derivative actions asking hard questions about some of these officers and directors. What were you looking at? Were you reviewing the financials? PwC gave you a qualified opinion on your audit. Did you take action in response to that qualified audit? There are a lot of people that perhaps didn't rise to the level of significant corporate sophistication that were serving as officers and directors, and they are now squarely in people's gun sights. If they go to Rich, if they go to any one of the practitioners around town that handle sophisticated individual cases, it's going to be interesting to see how that develops, to see how those practitioners look at this and respond and give advice that, gosh, perhaps that liability may be dischargeable, maybe not, but you may be faced with some significant legal expenses and some significant time and devotion to defending this lawsuit.
Is there a difference whether the company is in the zone of insolvency or if it's currently solvent and the shareholders versus creditors?
I think the difference is who's on the other side of the table. You're either, if the company is not bankrupt, continues to operate in some way, but there's been a defalcation, you may be looking at a shareholder derivative suit because your duty prior to the company entering the zone of insolvency, the Delaware Chancery Court can't seem to figure out how to define what that is, whether it's assets and liabilities, ability to meet debts as they come
Do you know it when you see it?
You do, sitting where you are. I'm not sure that I do. And I'm not sure that anybody does until you opine on what it's going to be. But in that situation, prior to the zone of insolvency, you're looking at a shareholder derivative suit. After the zone of insolvency is passed, and particularly if the company finds itself in a liquidation scenario in bankruptcy court, you may be looking at the creditors committee and able counsel for that committee, perhaps a lawyer retained by that committee who's taken on a contingent fee case, to come in and prove this A4 exception.
Rich Thomson, what do you say to the director or officer who comes into your office with a summons in their hand?
Go talk to John Thomson.
You got the wrong Thompson.
Do we see defalcation commonly alleged? Is there a plague of defalcation sweeping across the land? Do judgment creditors gravitate toward one exception or another?
I don't usually see defalcation alleged very often. Typically, they'll bring it under fraud, willful misrepresentation, conversion. I haven't seen very many defalcation cases, and typically they are in the lottery ticket sales context.
There is a thread of case law out there that suggests that non-pecuniary breaches of fiduciary duty can give rise to defalcation. Some courts have expanded defalcation to include situations where trust race is mishandled. Do you have an opinion on whether this should be?
You know, I think this panel may be split a little bit on that. I mean, I read the Bullock case, and the Bullock case troubles me. Those loans were repaid back to the trust. They were repaid back with interest. The trust suffered no net loss. Now, what we don't know from the facts of the case, either from the underlying decision or from the appellate briefs, we don't know what this family looks like. You've got two brothers suing another brother on a trust where there was no pecuniary, I mean, something else is going on there.
Probably don't have family picnics too often.
No, not anymore. But then you start to get, it goes downhill from there, because then you can fan out into a panoply of situations where one of the cases cited was a trustee who removed her trustee's fees under an order of the court to pay herself prior to the expiration of the 30-day appeal. This is a state court proceeding. It wasn't a bankruptcy court proceeding, but it may have been a receiver fee. Anyway, she paid herself before the order authorizing her to pay herself was non-appealed, final. And sure enough, somebody came and appealed, and then she had to go bankrupt, and in the bankruptcy, that party appealing came. The fees were already approved. There's no loss. So it troubles me where you see situations like this where people are going to be hung out based solely on conduct that resulted in no loss. If you go back to first-year torts, duty, breach of duty, and damage. I mean, there are lawsuits every day in America that don't get brought because there are no damages, and I think that's a similar context to what we have here.
Well, and that's where we get into trust law. Because, and I'm not a trust lawyer. Some people say I'm not a bankruptcy lawyer either. But in the law of trusts, there are various duties, and let's limit this first to the express trust that we have here, meaning a contractual document that creates a trust. And you have a trustee, you have a race, a certain defined property that is to be managed by the trustee, and you have specific beneficiaries. Classic technical express trust. A trustee has a number of duties, and a primary duty under trust law is the duty of loyalty. Loyalty to the principal. And the duty of loyalty means you can't use trust assets for your own benefit. Period. End of discussion. Next case. The trust guys don't worry about intent or anything else. You can't self-deal unless the trust instrument lets you, and so forth and so on. Which is why a lot of trust instruments in family situations say, yeah, you can make loans to families. But this one didn't. So there is a duty of loyalty. That means no self-dealing. How does the trust law look at that? The trust law says, this is applicable non-bankruptcy law, which bankruptcy lawyers often don't like to look at. Applicable non-bankruptcy law generally says the remedy for self-dealing by a trustee is the trustee can't keep the profits that are made by dealing with property that he's not entitled to deal with. And therefore, if you take $100,000 from the trust, go buy a lottery ticket and you win and you end up with $1 million, you owe the trust $1 million. And that's the loss and that's the damage. So in a sense, and that's this is the issue that's being argued before the Supreme Court, and I've just stated the position of the creditor, the trust. The other argument is that there has to be some actual loss in order to fit within the congressional intent of accepting these types of debts, and that if you have no loss and it is a no harm, no foul situation, then the concept of defalcation doesn't apply, and there is no exception to discharge for that.
Well, I've got a problem with that no harm, no foul approach. It reminds me of a recent criminal case that the 11th Circuit just decided. Chiropractor, a lot of Medicare fraud, hundreds of thousands of dollars. He got caught. Before he went to trial, he goes and repays every cent, hundreds of thousands of dollars. Does about 120 hours of community service, goes and speaks at chiropractic schools, works at local chiropractic free clinics, things of that sort. And he goes in and the district court says, wow, look at all this. You paid it all back without me ordering you to, and you've done this community service, so I'm going to give you a couple of days in jail and put you on some probation, and that'll be the end of it. Well, the state took it up to the 11th Circuit, or the United States took it up to the 11th Circuit, and the 11th Circuit said, whoa, wait a minute. You know, there's a policy here. What you've told this chiropractor is that as long as you pay it back, if you get caught, then and you pay it back, everything's fine. There's no ramifications. So what kind of policy is that? We need to send a message that this type of behavior is not acceptable. So they reversed and remanded back to the district court to impose a new sentence. Similarly, in this defalcation area, there is no harm, no foul, because A, there was an unnecessary risk of property that was entrusted to him. And just because, well, you were lucky enough this time, so you got away with it this time. Next time when you do something like that, you know, maybe the market won't improve. Instead, you invested this money in a real estate transaction. Well, we all know what happened to the real estate market in the last 5 years. You know, what was oversecured rapidly turned to be undersecured. So there's that policy that you are dealing with the trust of somebody else's property, and therefore we're going to hold you to a higher standard, and this no harm, no foul thing is incorrect. Also in this case, it's my understanding that the brothers didn't know about the trust at first. In fact, the petitioner didn't know about the trust at first until the father came to him and said, oh, hey, by the way, you're the trustee on this $1 million trust, and I'd like you to go borrow some money for your mother against the trust for your mother so she can repay back money that she owes to my company. And that was the first loan. Now I've just lost my train of thought.
Innocence.
Innocence. Oh, but the problem is the debtor, the brothers didn't know about it. When they found out about the trust and they asked for an accounting, that's when the petitioner repaid the money. He resigned and he repaid the money. So even though he repaid just enough to cover the interest that would have accrued in the trust raised, you know, technically there was no loss, but there was an additional loss because the brothers incurred expenses and attorney's fees in validating the trust itself. And so they can't say no harm, no foul. And so I think it is appropriate that there was a finding of defalcation in this case.
Well, you know, what we're struggling with, and should I say it? Sure. A lot of times when the Supreme...
Just don't say panoply, because if they put this in a publication, that's another footnote they're going to have to write for what that means.
You know, bankruptcy is a very specialized discipline, and it's hard to understand it until you see it in practice. You take the code and you apply it to the financial circumstances and the human circumstances that come before you. But the Supreme Court a lot of times struggles with bankruptcy issues. And we now have a Supreme Court that's getting ready to rule on something. And maybe they will. Maybe we can look forward to some real significant help on defining defalcation, because that's what it's going to twist on. There was a time in my work where I did a lot of work with bankers' blanket bond policies. And that essentially insures a financial institution against misdeeds of their employees. Kiting funds, escheating funds, anywhere where an employee would set up a scheme where they would defraud the bank of money in the course of their duties. The definition of defalcation in those policies was mind-numbing. And it went through 14 subparagraphs, but at the end of the day, there was no question as to what acts of an employee were going to be considered a defalcation, defined term, that would give rise to a loss. And what we're struggling with now, and Judge Bonapfel pointed it out at the very inception, fraud, larceny, embezzlement, those are defined crimes. Very easy to wrap your arms around what those are. What we're struggling with here is, again, the definition of defalcation. Is it an innocent mistake? If you are a lawyer and somebody comes to you and says, I need to perfect a security interest, I need to record a document in the public record, whether it's real estate or the UCC records, you're in a fiduciary capacity to that client, and things get busy, your calendaring system breaks down in your office, an associate leaves, there's some lack of, it doesn't get filed. It doesn't get filed, and there's a defined loss to your client. Is that a defalcation? Certainly you're trying to be a good lawyer. There's no intent that that mistake was made. There are some cases out there that are drifting in the direction of making that a defalcation, and that is troubling to me that you could get away with that.
Because defalcation includes breach of fiduciary duty.
Right.
And the lawyer, we would agree, I assume, has a fiduciary duty
Absolutely.
to the client to do what the client has asked.
There's a broad range of fiduciary duties in this world. Just walking around doing business, you create fiduciary duties, and you need to be attuned to when they're out there.
But those type of fiduciary duties don't stem from technical or express trust, and that's what we're dealing with 523A4.
We hope.
But for now, as far as we know.
Well, but the question is whether, and I don't think the 11th Circuit has told us that you have to have an express trust or a technical trust. It's also told us that the lottery situation in Georgia meets that. It can be a statutorily imposed trust. And so, therefore, the question becomes whether the obligation of a lawyer that the lawyer owes to a client is that type of fiduciary duty that is an express obligation.
Because you have circuits that are already coming down saying corporate officers and directors, certainly there's nothing expressed there, but that they are being hung with a fiduciary duty. And then you get to the big question of starting to go down in the weeds and say what kind of act in violation of that duty is a defalcation.
Well, and similarly, for innocent mistake or no bad intent, let's take the lottery sales. Client owns a convenience store. He sells state lottery tickets. He gets held up. Can't recover the tickets or the proceeds. Unfortunately, he mailed his insurance premium out a day late by mistake. Therefore, that loss wasn't covered by insurance. Would that be a breach of his or a defalcation in his fiduciary responsibilities such that that loss would be non-dischargeable?
Take a vote. How many people say yes? How many people say no? A lot of people say it. So a lot of people say, well, several people. How many people are asleep? Don't.
How many people are
understand the
judges,
question,
actually?
or don't care? Most of you fit into the last category. Okay, so most people think that would not be a dischargeable debt. Did I get that right?
Yeah, it's
The opposite. No.
Yes, most people think he ought to be able to discharge it because it hardly seems
Should be
fair.
able to discharge it. Okay.
He got held up. It hardly seems fair.
The trust law, I submit, would say that no, that is a breach of fiduciary duty, because if you are a fiduciary and you are entrusted with money, make it not the lottery owner, but the trustee of an express trust who is running a race is real estate, and he collects cash as rent, and on his way to the bank he's held up. I think that a classic treatment of trust law would say that rent is rent that is property of the trust, and he has an unqualified obligation to get that money and to account for that money. I think you will find some cases, the editors of this can look for these and put them in a footnote to make me look smart and
With
edit out
monopoly.
the part I just said. But I think you will find some cases from the Depression area where maybe Mr. Walensky could help me out with this because he was around then, I think. I think you will find some cases from the Depression area where a receiver or a trustee who put money in a bank that failed was liable for the money. Clearly, that's an innocent type of act, but there is this liability that you have as a trustee to account for funds that are entrusted to you.
That kind of liability makes sense. We have doctrines like duress and coercion in criminal law that help people out when they're forced to do things or are put in really tricky situations that are not of their own making. Why would that not make sense in a trust context as well, especially when we're talking about federal common law and an exception to discharge?
Well, it's not criminal.
Right.
For one thing, so it's a different thing. But and what I'm really doing, if you're interested in this, you should find the amicus brief written by on behalf of the law professors in the Supreme Court case, because this is basically their pitch, and their pitch is that in this exception, first of all, they would limit it to express technical trusts of the type that I just described, which is a trustee for a defined race with a named beneficiary. So that would presumably exclude the malpracticing lawyer and the corporate D&O guy, okay? So that limitation would take all of those cases out of the A4 defalcation problem, because we're only talking about a trust that meets those three requirements. Probably doesn't help the lottery guy, because there is a race, the lottery proceeds, and a designated beneficiary, the lottery commission, and that person is the trustee.
Well, I think you are leaving out one element of that trust relationship. Yes, there has to be a beneficiary, there has to be a trustee, there has to be a race, but there's also a requirement that there are specific fiduciary responsibilities enumerated.
Right.
So in the case with my guy, the convenience store owner, if he was required to keep insurance in place, then he probably had a defalcation.
Right. So the law professor's argument, someone once said lawyers look for answers and law professors look for questions, but these guys may have it right, and we'll see whether the Supreme Court follows that or some other standard. But their conception of 523A4 is that Congress, almost since inception of a dischargeability exception for defalcation, which goes back to the 1840 Act, has intended that the statute protect beneficiaries of a trust, period. That's what defalcation is all about. That's their argument. And if you take that argument and if you apply it only in the express trust area, then they say that the level of scienter or intent or the subjective requirement is determined solely by state law or by trust law, because it's to protect the beneficiary. And if you accept that, then it follows, it seems to me, Mr. Bullock is not going to prevail because of what I said earlier, which is he violated his duty of loyalty. One can quibble over whether there really was that much loss. One can quibble under the facts or reasonable inferences from the facts that we as bankruptcy lawyers might like to invent, that all of this really was a family thing, and the father knew it, and it's not fair that the father knows it, and he's the one that set it up, and this was really his intent, and all of those things that are facts and circumstances which could make us believe this is an unfair result. And it's
$250,000 here, $250,000 there. All of a sudden, you're quibbling about
it's
real money.
Right? But so one can look at the facts of this case and imagine all kinds of circumstances on account of which one would say that's just not right. And if one is a bankruptcy judge, one might want to say, and I can fix it by saying it's accepted from discharge. But and here's one of the tensions in this case that, as we know, our Supreme Court may find interesting, and that's the federalism aspect of this. And so the question is, an Illinois court having resolved this question and said, under Illinois law, these beneficiaries of this trust are entitled to this protection of Illinois law of trusts, how far does the bankruptcy policy go in upsetting that and interfering with that? Sorry, I've made the argument for your adversary, but that's basically, so the law professors come down and they say there are these three, the circuits have split. I assume that's why the Supreme Court took this, because there are three standards that the lower courts have applied in determining this defalcation issue. And the law professors basically say, as law professors sometimes do, none of them are right. This is the way to analyze it. And it has the effect of, it seems to me, clarifying the issue, number one, and limiting the scope of 523A4, because their premise is, not actually their premise, but there is a footnote that they point out that they rely on a case from 1844, actually, that is the Chapman case. And in that case, the court held, that's where this technical express trust idea comes from. That's been around that long. I've talked too much, as usual.
Now, if the Supreme Court's willing to do that, that's great. His job is a little different than mine. My job is to try and give him the information so that he can do his job and to address the issue, give him the fair overview of the case law, and particularly as it pertains to where I think the position ought to go. What worries you about the Supreme Court is the Supreme Court could come down with a very narrow definition, and it's crystal clear going forward. What I think scares me a little bit from a practitioner just sitting behind a desk trying to advocate positions, if the Supreme Court gets too far down in the weeds on this and makes what they think is a narrow holding, but they leave it with applicable concepts, and I go back to a case that I struggle with, Emory Till, 2005 case, I think, Supreme Court.
That is the Till. Has nothing to do with dischargeability.
Has nothing to do, but by analogy.
It is a bankruptcy case.
But by analogy, it's a Supreme Court bankruptcy case, and it rules on what the appropriate rate of interest is in a plan post-confirmation. How do you do that? How do you write? And it was in the context of, I forget the exact type of automobile. It seems like it might have been a pickup truck, but whatever it was, they came down with a very broad, expansive sort of way to calculate post-confirmation interest. And all the time they're looking at the pickup truck, and they're kind of focusing on the pickup truck. But then but at the end it becomes a pronouncement, and all of a sudden I'm looking at an office building with a $30 million loan on it, and I'm trying to figure out, well, prime plus one, is that really right? Is that I mean, it spawned a maelstrom of litigation. It cleared nothing up for me, the commercial lawyer, trying to do commercial loans in a Chapter 11 post-confirmation context. I hope they don't.
Made life real easy in the consumer context because nobody litigates that anymore.
Well, and there you go. And so you hope when the decision in the Bullock case comes down and is issued that they don't stay so heavily focused on the express trust document and then sort of make a broad pronouncement. And then I've got corporate officers and directors, and I'm trying to deal with them, and I'm scratching my head saying, well, the Bullock case, who knows? I mean, that's your fear.
And they might choose one of the three circuit standards. In this case, which is an express technical trust case, but not limit it to that. And now you've got the prospect of that type of standard applying across the board in all types of cases. And now you have the problem of let's assume that the Supreme Court comes up with a mere negligence standard is enough, okay? The Supreme Court adopts that standard. Innocent mistake, too bad. It's a trust. You got that obligation. What about our lawyer who fails to record the deed? Is that going to be a defalcation while acting in a fiduciary capacity, even though it's an innocent mistake? thought he did it and he didn't, or something?
Oh, give us a definition. That's what you're hoping for.
I don't know.
Is that you get some guidance.
If you have a Supreme Court case that comes down that way, without limiting it, it may take another Supreme Court case to get the answer to that question. Chapman would tell us from 1844 that that is not the type of debt that is within the 523A4 exception, but I think it's, if I have stolen this correctly from Ed's research, the Janikowski case, 60 BR 784, Bankruptcy, Northern District, Illinois, 1986, 60 BR 784 would say that debt's accepted from discharge.
Well, aren't we really talking about the difference between a subjective standard and an objective standard? And if you look at the code section, it differentiates defalcation from fraud and embezzlement and conversion. And fraud, embezzlement, and conversion all have a subjective standard about them, requiring scienter and things of that sort and intent, whereas defalcation is juxtaposed against those other things, and it would imply to me that it's more of an objective standard. And what was objectively reasonable with the treatment of the corporate race. And to put the corporate race at risk for your own self-dealing doesn't sound objectively reasonable under trust law.
Which is what the 11th Circuit came up with. Right. The argument of the debtor in that regard is that because 523A4 has the words fraud, embezzlement, and larceny in it, this is the maxim of nascitur a sociis, which is you give more specific meaning and context to a word by looking at the words that surround it. In other words, the word is defined by the company it keeps. And so if you have words that say fraud, embezzlement, larceny, which imply some sort of wrongdoing, and defalcation is thrown in there, then Congress must have intended that there be the same type of wrongdoing subjective intent as part of that statute. The other argument based on the words of 523 is yes, but there are lots of other places in 523A defining other debts that are accepted from discharge where words like willful or malicious come into play, and so the absence of including those here really doesn't mean anything when Congress, and this may come down to a plain meaning case, which we also know this, the Supreme Court loves the plain meaning and apply the plain meaning of the words in the context of bankruptcy when a lot of problems are more difficult to solve than that. But if it comes down to a plain meaning test, then defalcation is going to mean what defalcation means, and the parties in their briefs have cited a number of definitions, and once again, going back to the use of the word in 1840, which will please, I'm sure, Justices Scalia and Thomas. But so if it comes down to that, then it's going to be, defalcation is going to be misappropriation, which is what happened, or a breach of fiduciary duty.
Well, that makes sense. It seems that defalcation actually goes all the way back to 1705. The Defalcation Act of 1705 brought it over from England. And back then, defalcation was simply used to refer to situations when you just didn't pay back the full amount. Let it be paid without defalcation. It was just let it be paid without any amount reduced. So does it make sense to have it apply to anything except financial crimes at that point, or not crimes, but financial situations? Because what we have is something that was plainly financial in nature all the way back then, and yet the case law over time has changed this plain meaning. Like, which plain meaning are we using?
That's why we have the Supreme Court. I've tried to get on it, but nobody will appoint me.
Moving forward in the bankruptcy code, defalcation doesn't really appear many other places. You don't read it in novels or see it in any other code context. Does it make sense to have words like this in the bankruptcy code, or should it just be written out?
Well, whether it makes sense or not, I'm not going to opine on, but they're sprinkled throughout all 11 chapters, or all 12 chapters of the code, 13 chapters, 15 chapters, whatever. They're sprinkled throughout the code. That's why
We
you
end
have
with chapter 50, but there's only one even-numbered chapter, 12.
Right.
So we don't have 15 total chapters.
Well, the code is full of words that have given rise to a lot of litigation. And they're in there. The problem with monkeying with the code is Congress seems unwilling to ever do it on a piecemeal basis. They do it in spurts. They save up issues, and then they make, whether you want to refer to them as omnibus, but they make larger reformations of a number of parts of the code. And what the most recent one was 2005. Maybe this goes in the hopper. Maybe there's a lobby that's willing to get behind this and start bringing it to Congress's attention. The problem is, as we know, is that Congress has got a lot of bigger fish to fry right now. They've got more things on their plate than trying to deal with this one specialized industry. So if the Supreme Court comes down in a way that creates, hopefully not, but in a way that comes in and creates more uncertainty, then maybe this gets on somebody's radar screen. Maybe some, either a banking lobby or some other lobby, starts putting this before congressmen, members of Congress, and it gets to the point of a bill, but I don't think that that is an immediate solution. I think whatever the Supreme Court comes down with in Bullock, we're going to be stuck with for a while.
Well, I think we'll take this opportunity to open it up for questions, if there are any questions from the group here. There are 2 microphones at the sides.
Good afternoon. Thank you, the panel. It's been a wonderful discussion. I've enjoyed it. My name is Michael Wiseman. I'm a second-year student here at Emory. I have one observation and then a question about issue preclusion. The observation would first be to Mr. Thompson's comment on the no harm, no...
Which Mr. Thompson?
Richard Thomson, yes, sir. The no harm, no foul argument that I believe it was the solicitor brought up in his brief. In that brief, the solicitor talks about the other portions of 523A4, such as embezzlement and larceny, and if the loss caused by those actions were to be repaid, you'd still be an embezzler or have committed larceny. But the distinguished characteristic is that those two require criminal intent, whereas defalcation, that's not the standard in all the circuits. So this is just one observation. My question has to do with how deep the court wants to get into relitigating judgments, because the debt here is a court-imposed judgment. It's unlike the lawyer who failed to file the deed and cause an actual loss. The loss here was based on a finding of self-dealing that this person should have what is in effect a punitive judgment for the benefit that he received. Now, Mr. Bullock represented himself.
That would not classically be construed by the trust law as being punitive. It would be restorative by taking back the benefit that the debtor got by the improper activity. So it's not, I understand the point, which is there hadn't been a loss, so it's really unfair to make him pay it back. But classical trust law would not see it that way.
Yes, Your Honor. I mean, parts of the law do say that a disgorgement would be compensatory, but we've argued in the merits brief that it actually has the effect of a punitive damage.
Right. It certainly has that effect.
But
it certainly has the effect of providing, in a sense, a windfall to the beneficiaries, because if the debtor hadn't done this, they'd be in exactly the same position they are.
And I'm glad you make that point, Your Honor, because that goes to my question about
Well, let's
preclusion.
back up for a second. The problem is is that you don't want to encourage trustees to put the trust property at risk, other people's property at risk for their own self-dealing. So yes, this time there was a benefit to the trust. What happens if the market had cratered and his investments all went south and that impacted 600,000, 400,000, whatever it was, of the trust property? The reason that they have these principles in place and these remedies is to discourage this kind of self-dealing at the expense of the beneficiaries. Here, it worked out where there was no loss. But the public policy should be, we don't want you doing this. If you're not authorized to do that, don't do it. If you do it, there are ramifications. And one of those things is you're not going to benefit by your own wrongdoings.
Well, that begs the question, sir, about whether this was actually self-dealing. And in your example, if the market had cratered, then there would be, unlike here, a loss of the raise. According to the most recent restatement of trust, there's a section 603, that says that the trustee's first duty in a revocable inter vivos trust, as this was, is to the settlor of the trust, not to the beneficiaries. Now, Mr. Bullock represented himself pro se in the state court case, so he wasn't sophisticated enough to bring up this argument. So the question of whether this even was a self-dealing.
Let's back up again. I believe this was an irrevocable trust. At least that was my reading of the brief.
But it may also be applicable in principle to irrevocable trusts if they're inter vivos. And that's a very new provision that has not, it's a first impression in many circuits.
But we don't know what the trust was.
This goes to my question about issue preclusion, because if that's the case, that the self-dealing may have been improperly decided, how deep is the bankruptcy court willing to go to look at these judgments when there's no actual loss except for that's court imposed? Thank you.
Well, how deep does the bankruptcy court want to go?
Well, you found one of my hobby issues, which is issue preclusion, and that could be the subject of another seminar. The federal rule of, well, we have a statute, the full faith and credit statute, which requires a federal court to give full faith and credit to decision of a state court. Have 523C, which requires a bankruptcy court to rule on whether a debt is accepted from discharge under A2, 4, or 6. And of course, here we have 4. So we have an immediate tension as to whether the bankruptcy court can go behind that state court judgment on this particular issue.
Because if I come before you and I'm bankrupt and I'm suffering, I've had a wreck while I was impaired.
Right.
And I haven't been to trial yet.
Right.
You know, I haven't been fully adjudicated to be DUI at the time and therefore liable. That case has got to pin. That case has got to stay open because you can't rule on that. That's
I could rule on that. I could determine the dischargeability of that debt. Don't try that at home. But I don't have to because 523C doesn't require the bankruptcy court to do so.
Right.
So here we have a case where that fact has not been presented, and it may have a determinative effect on the outcome of the case as far as whether there was in fact a breach of fiduciary duty. So it raises a tough question in the first instance of whether the court can do that. The general reaction, I think, of federal courts in this context is and has been, you had the chance to establish in the Illinois court whether there was a breach of duty, whether there was a breach of the duty of loyalty by self-dealing. On that issue, And he fully litigated. If it's a default judgment, that raises a whole nother set of issues. But here he actually litigated that issue. As far as I know, maybe it was a default judgment. That would.
No, it was a summary judgment. It wasn't default.
Summary is, okay.
It was pro se
So
representation.
he appeared, he defended, and the Illinois court granted a summary judgment. And so he had the opportunity to raise this. He didn't raise it. So on the issue, if you define the issue as was there a breach of loyalty, that issue is determined. Whether that constitutes, and if you follow the law professor's view, which is that 523A4 is to protect trust beneficiaries, that would be the end of the discussion.
Well, I think that's all the time we have for
I just want to make one observation, and this is just maybe this illustrates the difference. Maybe this is why I'm not on the Supreme Court. This illustrates the difference between a bankruptcy judge's approach and an appellate court's approach to a case. Because after I read this case and I delved into the briefs a little bit, my question was, why is this case here? Why are you people bothering me with this case? Because so this is advice, maybe this is directed to the law students mostly, but maybe the lawyers. Who is looking after the interests of their clients in this case? Because the client is the trust. It has suffered a $250,000 plus attorney's fees, $285,000 loss. What did the trust get from the Illinois Supreme Court? It got a constructive trust, which is in essence a lien on this debtor's interest in his company, or maybe on the company's assets. The record's not clear as far as how much all that's worth, but it appears to be, based on at least the debtor's arguments, that if the trust would just let him sell his company, he could pay the $250,000. The lien doesn't go away. This is not a question about the lien. Even if this debt is discharged, the debt is discharged, but the debt still exists. Another little technical point for the students and some lawyers. The debt still exists. The personal liability goes away. So that means the lien still exists. And that means, notwithstanding the automatic stay, notwithstanding the discharge injunction, they can enforce the lien on the assets. So why are we arguing about whether this debt is dischargeable when one party apparently and has the ability to get the debt paid in a way that the debtor can't affect through bankruptcy law anyway, and this whole question goes away. And we could have gotten to our lunch earlier.
And the last thought I'll leave you with, you can't appreciate it now, but you'll see it. Somewhere, there's a banking officer that's reading a report from Serengeti of a bill broken down by tenths of an hour with expenses. And who is that bank? I'm scratching my head as to who that banking officer that has allowed this to go forward and keep spending fees on it when he could have resolved it by selling the garage fabrication business 3 years ago. Who knows? You'll learn more about that when you
Thank you very much to our panelists. Let's give them a round of applause.
Hello. Before we all go to lunch, I would just like to say a couple quick announcements. My name is Steve Furketic. I'm the editor-in-chief of the Journal. Very briefly, thank you again to our panelists, but in particular, I would like to thank Ed. This is extremely unorthodox to have a student come up here and participate in a panel in this way. He's done a great job, put a lot of time into it. If we give him another round of applause, please. Also, I'd like to add that Ed has put an enormous amount of time into working on this project, and he edits our entire journal, and he's still looking for a job. So if there's anyone out there who was impressed by this panel, please seek him out during lunch, or send an email to any of the addresses listed on our webpage, and we will get him in contact with you. So thank you so much. Let's grab some lunch.